And our sixth panelist, I warned you this was the longest panel, is Abed Awad, attorney and founder of Sharia Wiz, presenting a proposal for a Muslim American alternative dispute resolution and mediation center.
Thank you very much, Courtney, and thank you for Canopy and the center, and a special thanks to Leanne for organizing this. Leanne and I, we worked together, and you'll see the published piece shortly, on a framework that we believe is required for a successful Muslim American mediation center. As my other panelists, Shan and Azam, explained, that Islamic law has a rich history of mediation and alternate dispute resolution. Unlike the American adversarial system, the pre-modern Islamic judicial system, it deferred to mutual settlement and resolution as a first course of action. Because disputes among Muslims have consequences on extended families and community relations. If disputes are not managed properly, tensions are not calmed, the disputes will create communal disharmony. So the objective of the Sharia, the objective of Islamic law, is to resolve these disputes to provide litigants with a win-win framework. It's not a winner-takes-all approach, and it's about maintaining communal harmony. So it's all about the community. We looked at the existing mediation centers, and we decided, Leanne and myself, that there are three building blocks that are required for us to have a successful and viable Muslim American mediation center. And those building blocks are the applicable substantive law, something extremely relevant to what the rabbi from the Beit Din just discussed, applicable procedures, including some reasonable discovery, and arbitrator and mediator competencies. I'm just going to focus on the issue of the substantive law. What law would the mediator arbitrator apply in a Muslim American family dispute? Now, under American law, all assets acquired during the marriage are marital assets or community property assets, whether 50-50 under a community property regime or distributed equitably under the equitable distribution regime. Unlike in pre-modern Europe, where the property of the wife had merged with the property of the husband, under classical Islamic law, a Muslim woman had independent legal status, which meant that any property that she acquires was her separate property. The husband had no legal or equitable claim to that property. And the same applied, that the husband's property would be his separate property. However, the wife would have a support claim against his property. Now, this was a revolution in pre-modern period where a woman has independent legal capacity, so it's intended to protect Muslim women. But today, the circumstances in the mode of production and economics in the United States, that had turned this concept upside down. So when we talk about what substantive law are you going to apply, if you're applying classical Islamic law, this is going to be problematic for most spouses litigating. It may even be contrary to public policy and not even enforceable. We go to even the next step about custody. With the pre-modern child custody, it involved a age-specific, gender-specific criteria to determine who the parent would have rearing guardianship, and the father would be the legal guardian by operation of law. There were good reason for organizing the custody arrangement in pre-modern times, but this would be contrary to public policy if it's applied in a arbitration setting. So here is the issue, is that we have to take into account that the substantive law for a sustainable mediation center would either be applying secular law, which may be objectionable, but rather to apply a modern, organically developed Islamic family law, a jurisprudence anchored in the Quran and the Sunnah, but formed and based on the current social and economic realities of living in the United States. For example, in the 10th century, Maliki scholars had noticed an inequity relating to divorce settlements and inheritance, where a wife was actively involved in working at the family business or at the family farm, and then not receiving her fair share. So they applied the methodology of the Sharia as a knowledge production moral system to remedy the injustice. They created a cause of action called al-kadwa si'aya. In the Maliki school, that means that any woman, wife, who contributes to the acquisition of the marital estate would have an equitable claim in addition to her black letter law rights under the Sharia. So under this theory, you could see that the Sharia is a methodology that produces knowledge, that is flexible, and the success and the fairness of the center will depend on this substantive law that is anchored in the specifics of the financial and non-financial realities of Muslim Americans in the US. This does not mean by any stretch of the imagination that Islamic family law has to become more American. This means making Islamic family law more in sync with the actual social and economic circumstances of Muslim Americans, the underlying objective of the Sharia. Thank you.